Here's a question. Is the surviving partner legally liable to repay a debt incurred by the deceased spouse, or can he or she seek exemption? The untimely death of a husband or wife not only leads to emotional trauma but financial distress as well. And among the many financial problems that surviving partners face, one is debt. To find an answer to the question, let us consider different categories of debt. Joint debt. A married couple usually opts for a joint home loan as joint applicants. If the primary applicant passes away, the liability for repaying a loan is passed on to the surviving co-signer or joint debtor. If a loan commitment is not honored by the living co-applicant, the lender can take legal recourse in the civil court, debt recovery tribunal, or under the Sarfaci Act, depending on the facts and circumstances. Also, while a co-owner is generally a co-borrower in a property, a co-borrower may not be a co-owner. A co-borrower accepts the responsibility for repaying a loan with the primary applicant but does not have ownership rights. Secured debt. If a spouse dies while honoring a debt commitment on a secured loan, the surviving partner needs to intimate the creditor about the death and provide a copy of the death certificate. If the living partner does not service the debt, the lender can take possession of the collateral or enforce the security. However, the lender cannot resort to coercive measures to compel the surviving spouse to make repayments, and any action for recovery or enforcement of security has to be as per the law. On the demise of a spouse, the security offered to the lender during his lifetime is enforceable. Unsecured debt. Since there is no collateral for an unsecured loan, property seizure for loan recovery is ruled out. If a person passes away before repaying an unsecured loan, the lender cannot claim unpaid dues from the surviving partner or legal heirs of the deceased. The legal heirs are liable to the lender only to the extent of the value or assets, if inherited from the deceased. If no assets are inherited, the surviving spouse or children have no liability towards the lender. For instance, if the husband leaves behind movable or immovable assets which are inherited by the wife, the creditors can claim all such assets from the surviving spouse in accordance with the law. The court in such an event can attach all such assets, and the creditors can recover the outstanding amount by selling these after initiating appropriate legal action. If the surviving spouse has given a personal guarantee to the creditor for fulfilling the obligations undertaken by the deceased spouse, the process of attaching, applying, or selling assets of the surviving spouse to recover the outstanding amount can be undertaken by the lender. If you have found today's video to be informative, then please go ahead and share it and let more people know about it. At Women on Wealth, we help women take charge of their finances. And if you are in debt and want to take charge of it, but have been struggling in bringing velocity in reaching your debt freedom, then please sign up for our intensive Debt to Freedom program. The link is in the description of this video. At Women on Wealth, many women have become debt-free and many more are on their way, and you can join them too. I thank you for watching this video, and I'll see you next time. Bye-bye.